Hello ladies and gentlemen, and welcome back to part 2 and the final part of the supplemental plea and the interlocutory appeal which she has tried to put in. And this is obviously now what Johnny Depp and his team, they're like, no, this should be dismissed, and they want sanctions. Obviously we went through part 1 yesterday, and this is what we got, so we're going to jump straight back into the argument. So, the court should decline the order for interlocutory appeal, a legal standard. Interlocutory appeals are strongly disfavoured under Virginia law because they often result in inefficiencies and unnecessary delay and expenses. By their nature, interlocutory appeals are disruptive, time-consuming and expensive. The general rule prohibiting interlocutory appeals preserves the trial court's independence and protects parties from the harassment of separate appeals of individual rulings. Accordingly, an interlocutory appeal is only permitted when the order involves a question of law to which there is substantial ground for difference of opinion. There is no clear, controlling precedent on point in the decisions of the Supreme Court of Virginia or the Court of Appeals of Virginia. Determination of the issue will be dispositive of a material aspect of the proceeding currently pending before the court, and it is in the party's best interests to seek an interlocutory appeal. Applying this authority, the court should deny her motion. Defendant cannot satisfy any of the 4 requisite criteria, all 4 of which must be satisfied for this appeal. Her motion to certify the court's order denying her supplemental plea in bar should be denied because none of the 4 requirements set out in Virginia Code is satisfied. It is not in Mr. Depp's best interest to seek this appeal. As a threshold and dispositive matter, AH cannot take this appeal of the letter of opinion because it is decidedly not in Mr. Depp's best interest to do so, which is not. As the court is aware, Mr. Depp filed this action in March 2019, 13 months after, by the way, when he paid the entire final divorce settlement. It was gone, she was out of his hair, that was it. But obviously, in 2018, towards the end, she decided to go and do the op-ed, which is what this has come about of. In the ordinary course of events, a trial on this claim would have taken place in the spring of 2020. However, because of what was going on with the pandemic and related orders from the Governor's Office and Supreme Court of Virginia, the trial of this case has been repeatedly continued and is now set for a 4-week jury trial in April of next year. The delays associated with the coronavirus have only been exacerbated by her scorched earth litigation tactics. Over the course of this litigation, she has hired and fired 3 sets of legal counsel in Virginia, California, and New York, and has been bolstered by a phalanx of counsel from the ACLU, who appear to be serving as adjacent counsel for her, notwithstanding the fact that she failed to make good on her $3.5 million pledge to the organisation. Oh. I don't know what that was. Excuse me. AH's successive counsel have used the additional time to file increasingly frivolous, dispositive motions and repetitious motions to compel, many of which have already been addressed and denied by the court prior to the transition of the case from Chief Judge White to Chief Judge Penny after the former's retirement earlier this summer. Granting AH's motion would open a new front of litigation before the Supreme Court of Virginia, almost inevitably lead to her seeking a stay of the litigation, as she has done in the past, which, if successful, would result in yet another continuance of the trial date, as much discovery, including her deposition, set for 3 days, has yet to occur. Obviously, with that there, we're talking about she would probably want to get this postponed again until after Aquaman 2, because no one knows what she's got coming up in the job-wise. All we've heard is Daniel Rickman, who you have to pay to hear these rumours that, oh yeah, she's going to have a Mirror TV show on HBO Max. Even though nowhere else has heard any of this. And a lot of people do have, obviously, sources inside these movie companies. And it's just like, how come you're the only one who's saying this? But we have seen that Daniel Rickman, for some unknown reason, he does like to be on her side for anything that she does. All of these delays and AH's specious litigation tactics have come almost entirely at Mr. Depp's expense, as AH does not appear to be paying for her own counsel, but rather having a third party or parties foot the bill. AH's tactics have increased Mr. Depp's legal expenses and delayed the vindication he seeks against her for the false claims of this. Moreover, the events at issue took place years ago, and the memories of witnesses to these events will not improve with time. These expenses and delays associated with the interlocutory appeal are precisely why these appeals are disfavoured under Virginia law and should be denied where, as here, it is not in the party's best interest to incur these expenses. Her motion for this appeal can and should be denied because it is diametrically opposed to Mr. Depp's best interest. In support of her motion, AH speculates that this appeal would actually be in his best interest because a ruling in her favour would save Mr. Depp millions of dollars in not pursuing the next 9 months of expense, discovery, going down, and motions practice, as well as trial preparation and the 4-week trial. In any event, Mr. Depp would not be prejudiced by the delay if he was to prevail because, given his litigious nature, the cost of briefing an appeal in this case will almost certainly be expended either way. This argument, however, is self-serving obfuscation. First of all, Miss Hurd's contention that a ruling in her favour would save Mr. Depp millions in these litigation costs ignore the fact that this action includes counterclaims by her against Mr. Depp, which for the reasons set forth would not be resolved by such a ruling. Second, her argument that Mr. Depp would not be prejudiced if he were to prevail on appeal ignores the fact that this case is not just about money for Mr. Depp, which is not. We've all talked about this. He just wants it to be like, this is the person everyone just seems to be loving. Why? I'm going to show you the real person. Mr. Depp brought his action to clear his name against a false claim of this, which have negatively impacted his reputation and professional opportunities. Any incremental delay in litigating this case on the merits caused by an appeal would further delay the vindication that he seeks, and thereby exacerbate the reputational and monetary damage that he has suffered as a result of her false claims. Finally, while it is likely that the cost of litigating Mr. Depp's defamation claims through trial would exceed the cost of briefing an appeal, her argument ignores the fact that the cost of briefing an appeal is incremental. It is an added cost on top of the costs that he will incur in litigating his claims through trial. Regardless of the outcome of this appeal that she seeks, the appeal is not in Mr. Depp's best interest. Now it's going on to determination of the issue of whether the UK judgment precludes defamation claims is not dispositive of a material aspect of this action. AH's request for an interlocutory appeal should also be denied because the appeal would not be dispositive of a material aspect of this action. Her argument that the reversal of this court's order denying her supplemental plea would be dispositive of a material aspect of this case ignores the fact that she herself has a $100 million counterclaim pending against Mr. Depp, which would not be resolved if the UK judgment was afforded preclusive effect. I do apologise for my voice. I don't know why. I've had it all morning. It feels very tickly. I've done tests. Don't worry, we're all good about that. But for some unknown reason, my voice is just sounding like this. I could be losing it. We don't know. But I tried to apologise for my voice. As AH recognises in her motion, she could not use the UK judgment offensively to ban Mr. Depp from defending against her counterclaim because the mutuality requirement should be strictly applied when offensive collateral estoppel is invoked. Going on, for obvious reasons, it is far more important that the mutuality apply to offensive collateral estoppel to prevent defendants who never had a day in court in one case from being adjudged liable in a latter case. In any event, even if the UK judgment precludes Mr. Depp from relitigating whether her claims of this are false, which it decidedly does not, it would not resolve AH's surviving counterclaim against Mr. Depp. AH's surviving counterclaim is a claim for defamation based on statements made by Mr. Depp's attorney, Adam Waldman, which are of a different nature than the statements which are the subject of Mr. Depp's defamation claims. The UK judgment accordingly would not preclude the parties from litigating whether the statements which are the subject of AH's defamation counterclaims are true or false. Moreover, although AH alleges the purportedly defamatory statements were made by Mr. Depp through his attorney, this is hotly disputed fact which would still need to be litigated. In sum, even if AH has successfully appealed the order, a material aspect of this action would remain pending before this court. There is no substantial ground for difference of opinion on whether the UK judgment precludes Mr. Depp's defamation claims, and there is clear, controlling precedent to this point. We are coming out to the 10-minute mark, but we have got a couple of pages left. Finally, AH's motion to certify the order's appeal should be denied because Virginia law is clear that this court need not recognise the preclusive effect of the UK judgment. The court's letter opinion, which thoroughly addressed controlling Virginia precedent, demonstrates the clarity of Virginia law on this issue. In addressing AH's argument to abandon the mutility requirement for collateral estoppel, the court made this point patently clear. This is not a matter of first impression, it is a matter of stare decisis. Based on the abundance of binding case law holding mutuality, it is still a requirement in Virginia. Collateral estoppel is not appropriate here. Letter opinion at 5. Ironically, even the authority cited in her support of her argument that Virginia law is not clear in the application of non-mutual collateral estoppel, and there is substantial ground for difference of opinion on this point, demonstrates precisely the opposite. She then contends that in this other case, the Supreme Court of Virginia set forth a clear exception to the mutuality requirement for collateral estoppel. The Supreme Court of Virginia, however, did no such thing. As the court observed in the letter opinion in Bates v. Devers, the Supreme Court of Virginia held that collateral estoppel was not applicable and addressed the mutuality requirement only in a single footnote. In that footnote, the Supreme Court of Virginia noted that the mutuality doctrine should not be mechanistically applied when it is compellingly clear from the prior record that the party in the subsequent civil action against whom collateral estoppel is asserted has fully and fairly litigated and lost an issue of fact which was essential to the prior judgment. The dicta relegated to a single footnote is not a clear exception to the mutuality requirement for collateral estoppel. As is clear from the precise language of the footnote, the Supreme Court of Virginia is merely noting that the mutuality doctrine needs not be mechanically applied in a particular circumstance. It is not holding that there is no mutuality requirement at all in that particular circumstance. AH contends that the bounds of the Bates exception, which is no exception at all, have not been fully explored. I do apologise. Have not been fully explored by the Virginia Supreme Court or the Court of Appeals of Virginia. To the contrary, as set forth in the letter opinion, the Virginia Supreme Court has re-examined the issue of mutuality multiple times since the Bates decision and reaffirmed the mutuality requirement. In both this cited in the letter opinion and Rawlings cited by Mr. Depp's briefing in opposition to the supplemental plea, the Supreme Court of Virginia was presented with a defence of collateral estoppel and held that the doctrine did not apply because of lack of mutuality. Going on. AH argues that the decision in this is not clear or controlling precedent because the factual issues in the two litigations were not identical. Circumstances did not satisfy the Bates exception. Setting aside the fact that there is no Bates exception to satisfy, a difference in factual circumstances cannot divest this one of its status as controlling precedent. Otherwise, there would be no clear and controlling precedent at all. In any event, in Rawlings, the factual issues in the two litigations, whether the defendant was negligent, were the same, thus satisfying the so-called Bates exception. AH has devised, and even under those circumstances, the Supreme Court of Virginia declined to recognise non-mutual defence of collateral estoppel. See Rawlings as one here. Holding that claim against defendant were not barred by collateral estoppel because there was no mutuality. AH's contention that there is no controlling Virginia precedent on non-mutual defence collateral estoppel is, like her claims of this, demonstrably false. The only other authority that she can cite to in support of her request for the appeal are the two dissenting opinions in these different cases. however, is yet another example of Virginia Supreme Court addressing a plea of collateral estoppel after Bates and following established precedent resisting the so-called modern trend to abrogate the mutuality requirement. The Supreme Court of Virginia's decision in selected risks is thus precisely the type of clear controlling authority that demonstrates there are no substantial grounds for differing opinions on the issue that she seeks to certify for this appeal. I am going to stop it by there because as we go through, it is just a few things. They're just saying different court cases now because of what she's asked for. It's not going to work. It goes through quite a few, and obviously the ending part of it. The court should order her to reimburse Mr. Depp his reasonable costs and attorney fees for responding to her motion. He has spent in excess of $100,000 successfully opposing her supplemental plea. Although the court denied his related request for sanctions, it made clear that AH's supplemental plea bordered on frivolous, finding it misguided and only thinly supported by pre-existing law. Letter opinion at 10. With AH's motion, the case is now in a different procedural posture. The supplemental plea may not have been sanctionable, but seeking an interlocutory appeal of the order denying the misguided and thinly supported supplemental plea should be this. Because his appeal is interlocutory and frivolous, we grant the motion for sanctions in the form of single costs and attorney's fees in favour of the appellees. Now, it does say about that the Virginia law, it does not countenance a party submitting the pleading or the motion that is unfounded in fact. And it just says, this is what we got. She's gone against it. It's not exactly good. Everything she is saying is complete BS. And then it goes down to the conclusion. For the foregoing reason, Ms. Depp respectfully requests that the court deny her motion and impose sanctions on her for filing this frivolous motion in the first place. And then obviously it just goes down for a few other things. But that's what we got, ladies and gentlemen, and it's actually a really good document because I will leave a link to it below. And as we've seen, the amount of stuff that this person has gone and done, the amount of documentation that she has put out there for people to read, like all of us, a big thank you to Laura as well for putting all these out there because she does get them before they're put on the actual website. And it's just sad to see that Heard thinks she can just, I'm going to put so much out there, everyone's going to get bogged down. The Chewbacca defense, as we mentioned last time. And she's just like, I'm going to win this. Like I said, this is what Elaine supposedly does. She gets people to settle out of court and she gets cases dismissed because she just throws so much shit at them. They're like, oh, we can't be bothered to look through all of this. And this is, at this moment, it seems to be what she's doing here. I am actually going to be live just after this video, so stick around. It should actually put you over to the live stream. So let me know if it works, if you come on in and it worked. If it did, amazing. YouTube is finally doing something great. If you are new to the channel, please like and subscribe for future videos like this and other things, and I'll see you all very soon.